So, my name's Paul McGuire. I'm one of the nursing officers with the Mental Welfare Commission, and I'm going to speak to you about specified persons. So, specified persons is a huge area, lots and lots of information that I probably won't all get through today, and that's why the Commission have our good practice guides. So, good practice guidance on specified person you can find on the Mental Welfare Commission for Scotland's website. All the information that I'm going to speak about today is on that good practice guide. So in terms of the background, the first couple of slides I'm just going to read out to you and then elaborate as we go along. So the Mental Health Care and Treatment Scotland Act 2003 introduced the concept of specified persons in respect of authorising restrictions on individuals' correspondence, use of the telephone, and also in relation to safety and security in hospitals. This means that where the responsible medical officer is considering applying such restrictions, the patient concerned must be designated as a specified person. In terms of a definition, this is one that I found on Scottish Government's website in relation to the Mental Health Act. If a person is detained in hospital under the Mental Health Act, there may be times when they're so unwell that restrictions are placed upon them. When this happens, they are referred to as a specified person. This must only happen if a doctor thinks your health, safety or welfare might be at risk, or there is a risk to others. Regulations and law provide safeguards that the doctor must follow. People should only have restrictions placed upon them if it's absolutely necessary, and these restrictions should be as unobtrusive as possible. In regard to the sections of the Mental Health Act that we're talking about for specified persons, it would be sections 281 to 286, and more specifically 281 to 283 relates to correspondence, 284 to telephone use, and 286 to safety and security. The information there in purple is the view of the Commission that specified persons and associated restrictions should be used only in those circumstances which are beyond the scope of normal care and treatment. They are not a substitute for appropriately implemented ward or hospital policies applicable to all patients, detained or not. Applying restrictions of this kind to a voluntary patient would amount to a breach of their human rights. It is therefore reasonable and appropriate for all hospitals to have, as standard, their own robust protocols and policies in place. So in Scotland, as all of you all know, we have a forensic estate, which has 3 different levels of security. And in regards to specified persons, the state hospital would be the highest level of security. All patients in the state hospital are automatically designated as specified persons in respect of all restrictions. For medium secure care, like Rahalian Unit in Perth, Roundbank in Glasgow, and the Ulster Clinic in Edinburgh, all are automatically specified persons in respect of safety and security. And you can imagine that's for things like room searches and person searches and such like. However, patients in these settings need to be individually specified by the RMO, together with a reasoned opinion for any other restrictions that are required. In regards to other wards, all other detained patients have to be individually specified with a reasoned opinion if the RMO considers that restrictions on their correspondence, use of the telephone, or are required, or regulations attached to safety and security are necessary. In general, making a detained patient a specified person allows for the specific restrictions required to be in place for a period of up to 6 months. In regards to the community, for anyone who may be required to have restrictions applied in a community setting and who lack capacity, consideration should be given to applying through the court to appoint a welfare guardian under the AWI Act 2000. The Sheriff has authority to grant appropriate powers of a restrictive nature where necessary. Anyone with an interest in the adult's welfare who is opposed to these restrictions can make representations at the hearing with the court's permission. However, where a patient under a welfare guardianship order with restrictive powers is detained in hospital for treatment, specified persons would still be the appropriate authority to authorise restrictions in the hospital, as it can be appealed by the patient or named person with greater ease rather than going back to court. So all detained patients should be able to freely correspond by letter with whomever they like, contact people by telephone, not be subject to searches of themselves or their belongings, or have restrictions placed on their visitors other than that what would be applied in all other patients, regardless of their status. However, as mentioned, if the RMO deems the person is requiring to have restrictions placed on them, then a reasoned opinion would outline the details of this. The regulations state that an RMO must, within 6 months prior to any restrictions being implemented, have a recorded reasoned opinion that without restrictions being in place, there would be a risk to the individual or to others. The precise wording in the regulations varies depending on the nature of the restrictions. This action, together with notification to the patient's named person, and the Commission, would legally constitute the designation of a patient as a specified person. In order to make a reasoned opinion, the RMO needs to be in possession of a significant amount of information about the patient. So they have to have interviewed them at least once. RMOs should be clear that their reasoned opinion can be supported by additional sources of information, such as nursing notes, incident reports, social circumstances reports, as well as previous information of direct relevance to the restrictions proposed. It should be remembered that principles of the 2003 Act apply to all its sections and the associated regulations. Therefore, the principles of least restriction and of patient participation are of particular importance in the implementation of these regulations. The regulations are not intended to be applied in a blanket manner, as Claire mentioned earlier. Designation as a specified person is automatic in some settings, as we mentioned. However, designation does not automatically imply that the regulations should be implemented. So who should be informed? In addition to the RMO's reasoned opinion, the managers of the hospital are required to formally notify the person specified, their named person, and the Commission. There is an exemption to notifying the person specified if the RMO considers that doing so would be prejudicial to the person's mental health or treatment. Hospital managers are also required to inform the person specified and their named person that they are entitled to one review of the reasoned opinion in any 6-month period. The patient can request a review by the RMO once during any 6-month period, as stated. The outcome of any review must be communicated to the person concerned, his or her named person, and again the Commission. Notification to the specified person should always be in writing, other than in cases where to do so would be deemed detrimental to the person's mental health. The written information should include any restrictions applied, timescales involved, and the right of appeal. The Mental Welfare Commission does not have the power to review the specification of an individual patient, but can prohibit the implementation of the regulations where we believe that they are inconsistent with the principles of the 2003 Act. As mentioned a couple of times today, the European Court of Human Rights plays a massive part in mental health care and treatment in Scotland and across the world, or across Europe certainly. So care should be taken to ensure there is no unnecessary breach of an individual's human rights. The Human Rights Act 1998 incorporates the European Convention of Human Rights into domestic law, and any interventions provided by care staff must comply with the ECHR, especially Article 2, right to life, Article 3, right to be free from torture or another inhumane or degrading treatment, Article 5, right to liberty and security, and Article 8, right to respect for private and family life. So, what we have noticed in some secure units during our local visits and individual visits to patients is we're aware that in some areas admission to intensive psychiatric care units or low secure forensic units has resulted in almost automatic designation of a specified person. The Commission's view would be that we do not think this practice is compatible with the principles of the 2003 Act, nor with each individual's human rights. Unless patients are in the state hospital or a designated medium secure facility, they should not be designated as a specified person by virtue merely of being admitted as a patient in that particular ward. So we'll get into the nitty-gritty about the areas that people can be restricted. So use of telephones, where restrictions around telephone use are deemed necessary and where the person disagrees, then the RMO has to have recorded a reasoned opinion which supports the restrictions imposed. The reasoned opinion has to be made, as mentioned, in the 6 months prior to the implementation of the restrictions. The RMO has to determine that a telephone call made to or by the person detained may cause distress to that person or any other person who's not staff of that hospital, or cause a significant risk to the health, safety or welfare of that person, or safety of others. Note that the criteria in relation to other people, people other than the detained patient, are limited to their distress and their safety. Where the RMO considers the patient's use of telephone generally is likely to cause distress or constitute a risk, they can be prohibited from using the telephone for a period of up to 3 months. A less broad restriction limiting the frequency, duration or range of people who can be called can also be put in place. Again, the maximum length of time the restriction can be in place is for 3 months. Intercepting, there are powers to intercept incoming and outgoing calls in certain circumstances. These would be where the person who is the recipient of the call has requested the calls be intercepted, or where the call is or would be unlawful for any reason. So overall, when a patient is specified in respect of the use of telephone, the RMO can prohibit their use of the phone, restrict the duration, frequency and range of people to whom calls can be made or be received. So I'll move on to requests for review, which is at the bottom of that. The person specified can request a review of the particular restrictions or prohibitions once every 3 months. They can also request a review of their specified person status once every 6 months. In addition, if calls to or from an identified person are prohibited for a continuous period of 7 days, then the specified person is permitted to request a review on one occasion during each period of 7 days in respect to this one prohibition. The specified person can also ask the Commission to review the restrictions, and we may do this after this review, issue directions to the hospital managers in respect of the restrictions on their use of the telephone, the period of time for which the restrictions are in force. Although there is no time limit stated in the regulations in respect of the request to us, we would normally carry out a review on a more frequent basis than set out for the RMOs. The specified person can request a review of particular restrictions or prohibitions every 3 months.